Twilight of the Gods is a book about the Scopes monkey trial. Probably today, not a lot of people remember the Scopes monkey trial. It took place in 1925 in Dayton, Tennessee, and was a prosecution of a high school teacher for breaching a state act which prevented teaching of evolution. At the time, it was a huge event, and in the 50s, interest in it was revitalised by a play called Inherit the Wind, which was quite successful. That was made into a film in 1962 starring Spencer Tracy and Frederick March, and then the film has been remade for television about 3 times. There hasn't been much in the way of remakes of the film, so that probably it's drifted from memory, but the trial is still a significant event. What it was about is that William Jennings Bryan, a fundamentalist Christian and left-wing politician who twice ran for the Democratic nomination, was an opponent of evolution. The reason he was an opponent of revolution was that in the 20s, evolution as a theory was something which was very much mixed up with the notion of eugenics. Eugenics is an area of what was thought to be scientific study, but has since shown to be charlatanism. A study of the comparative ability of races and ideas around what would be described as racial health. So people advocating eugenics in the 20s suggested that society should do things such as sterilise disabled people, some suggestion of maybe euthanising babies if they failed short of perfection. And eugenics also saw a ranking of races, so that the white race, for instance, was seen as the most superior, and then other races were seen as subordinate, having some skills and ability, but not as much as the white race. The Afro-Americans were seen as the lowest and similar to apes. Eugenics went out of existence largely as a result of Adolf Hitler adopting it, and the very idea has been very discredited by what took place in Nazi Germany. As a result of that, eugenics has never survived and is simply something which is faded from history. But back in the 20s, evolution and eugenics were tied together, and the textbook which formed the basis of the teaching and the prosecution was one which not only talked about Darwin but also had a hierarchy of races, with Africans being similar to apes. So Bryan was a politician who was opposed to eugenics because effectively he favoured the common man, and a good deal of his life was devoted to policies which are aimed at improving the living standards of poorer people. When he ran for president, his main policy was to take the country off the gold standard to increase economic activity. As a result of agitators such as Riot in Tennessee, a person called John Butler was able to get the local legislature to pass a law which made teaching evolution a felony. At that time, the American Civil Liberties Union decided to try to run a test case to find the legislation invalid. Up to that time, the ACLU hadn't been that active in legal issues. It been mainly involved in trying to protect people who didn't want to be conscripted in the First World War. But the ACLU decided to run a test case. They had a discussion with some local businessmen in Dayton, in Tennessee, and the businessmen were keen to have a trial there because they thought it would bring a lot of publicity to the town and create a bit of economic activity. This in fact happened, and during the period of the trial apparently a good deal of the population moved out and rented their houses to people who came to actually see the trial. The mechanics of running a constitutional challenge to a law are that you have to get somebody or other found guilty of a law and then appeal it to a higher court to try to find the law was invalid. In this case, a person called Scopes agreed to be prosecuted. He was a relief teacher at the local school, and in fact there's a big question about whether he actually ever taught evolution. On one occasion apparently he took over a science class, but there had to be some manipulation with the local students to be able to get them to swear up before a grand jury before he could be indicted. Bryant decided to volunteer to prosecute the case, and at that stage in his life Brian was a person who was making most of his money out of selling books and doing lecture tours, and he no doubt hoped that his profile in the case could be raised so that he could make more money. Clarence Darrow was probably the most famous lawyer in America at the time. He was an atheist, and he's also a person who'd been heavily involved in representing unions in a range of complex cases in California and other places. He was involved in a bribery scandal where a person employed by him was caught paying $4,000 to a juror, and he had 2 trials for the equivalent of perverting the course of justice, and one won, the other was a hung jury, and he agreed to not practice in California again on the basis there wouldn't be a second trial. He lost a lot of his potential work from the union movement and moved more to the focus of criminal law, and he was also a person who was probably wanting to raise their profile a bit. The way the trial played out was that basically Scopes was always going to be found guilty, but what the defence wanted to do was to put into the trial as much evidence as possible to suggest that the theory of evolution was correct. And if they could do that, then they could make a stronger case for suggesting that the law was ludicrous or invalid. The difficulty is, of course, that the question about whether evolution was true or not wasn't really valid to the prosecution, which merely is a question about whether Scopes had taught evolution. So that a good deal of the trial was basically aimed at trying to have legal arguments to get this material in. At one point, the prosecution had finished, the defence had been leading evidence, and there was a period of time where the defence had effectively nothing to do and run out of witnesses. What happened was that they decided to call Brian as an alleged expert to give evidence on the Bible to try to point to discrepancies or absurdities in the Bible material again to be used in an appeal. Brian went into the witness box and he was cross-examined at some length and effectively found extreme difficulty in not appearing absurd. A good deal of his testimony added to the overall drama, and it's the sort of thing which got a lot of publicity through America. In the end, Scopes was duly found guilty. He was fined $100, and then the appeal process began. The problem at that stage was that nowadays the Bill of Rights has been seen to apply to state legislation, but it wasn't in those days. So the lawyers for Scopes effectively had to argue in the state Supreme Court under the freedom of expression rights in that state. In the end, they weren't successful, and basically the law was able to continue in its form. Scopes was found not guilty on a technicality, and that was that the Supreme Court found that the question of Scopes' penalty should have been decided by the jury. The judge didn't have power to do it, and therefore the penalty was invalid, and no one wanted to have a second trial, so effectively Scopes emerged without any conviction. Following the trial, both sides claimed victory. The law remained in place, yet the ACLU claimed a victory because effectively the general publicity they'd got made them look the more sensible party, in part due to the testimony which Brian gave, which looked a bit ridiculous, and the role of eugenics wasn't pushed forward so as to discredit the ACLU's approach to it. In practice, what happened was that the education system in Tennessee tended to teach much the same stuff, but they stopped using the word evolution in their textbooks. So broadly, the type of things which are taught simply continued on. But the defence, in fact, never won. In later years, in the films versions and the play versions, the defence was played to be the sort of right party, and they were made to appear to be the good persons in the narrative. But this was done by simply leaving out the various eugenic doctrines which compromised the purity of what they were arguing for. The book's quite interesting, but possibly it's an issue which has probably moved into the past and got to the point of where it isn't that relevant to what people are interested in anymore.